In this video, I'm going to take you through a reading comprehension which was asked in one of the law entrance examinations in the past years. Usually in the examination, I would be first reading the questions to get a sense of what is to be searched for in the passage. Here, you can pause the video and read the passage on your own. The passage. The World Trade Organization (WTO) was created in the early 1990s as a component of the Uruguay Round negotiation. However, it could have been negotiated as part of the Tokyo Round of the 1970s, since negotiation was an attempt at a constitutional reform of the General Agreement on Tariffs and Trade (GATT), or it could have been put off to the future, as the US government wanted. What factors led to the creation of the WTO in the early 1990s? One factor was the pattern of multilateral bargaining that developed late in the Uruguay Round. Like all complex international agreements, the WTO was a product of a series of trade-offs between principal actors and groups. For the United States, which did not want a new organization, the disputed settlement part of the WTO package achieved its long-standing goal of a more effective and more legal dispute settlement system. For the Europeans, who by the 90s had come to view GATT dispute settlement less in political terms and more as a regime of legal obligations, the WTO package was acceptable as a means to discipline the resort to unilateral measures by the United States. Countries like Canada and other middle and smaller trading partners were attracted by the expansion of a rule-based system and by the symbolic value of a trade organization, both of which inherently support the weak against the strong. The developing countries were attracted due to the provisions banning unilateral measures. Finally, and perhaps most important, many countries at the Uruguay Round came to put a higher priority on the export gains than on the import losses that the negotiation would produce, and they came to associate the WTO and a rule-based system with those gains. This reasoning, replicated in many countries, was contained in US Ambassador Cantor's defense of the WTO, and it announced to a recognition that international trade and its benefits cannot be enjoyed unless trading nations accept the discipline of a negotiated rule-based environment. A second factor in the creation of the WTO was pressure from lawyers and the legal process. The dispute settlement system of the WTO was seen as a victory of legalists, but the matters went deeper than that. The GATT and the WTO are contract organizations based on rules, and it is inevitable that an organization creating a further rule will in turn be influenced by legal process. Robert Hoodie had written of the momentum of legal development. But what is this precisely? Legal development can be defined as promotion of the technical legal values of consistency, clarity, or certainty, and effectiveness. These are values that those responsible for administering any legal system will seek to maximize. As it played out in the WTO, consistency meant integrating under one roof the whole lot of separate agreements signed under GATT auspices. Clarity meant removing ambiguities about the powers of contracting parties to make certain decisions or to undertake waivers. And effectiveness meant eliminating exceptions arising out of grandfather rights and resolving defects in dispute settlement procedures and institutional provisions. Concern for these values is inherent in any rule-based system of cooperation, since without these values, rules would be meaningless in the first place. Therefore, create their own incentive for fulfillment. The moment of legal development has occurred in other institutions besides the GATT, most notably in the European Union (EU). Over the past 2 decades, the European Court of Justice (ECJ) has consistently rendered decisions that have expanded incrementally the EU's internal market, in which the doctrine of mutual recognition, handed down in Cassis de Dijon case in 1979, was a key turning point. The court is now widely recognized as a major player in European integration, even though arguably such a strong role was not originally envisaged in the Treaty of Rome, which initiated the current European Union. One means the court used to expand integration was the teleological method of interpretation, whereby the actions of member states were evaluated against the accomplishment of the most elementary goals set forth in the preamble to the Rome Treaty. The teleological method represents an effort to keep current policies consistent with slated goals, and it is analogous to the effort in GATT to keep contracting party trade practices consistent with slated rules. In both cases, legal concerns and procedures are an independent force for further cooperation. In the large part, the WTO was an exercise in consolidation. In context of a trade negotiation that created a near revolutionary expansion of international trade rules, the formation of the WTO was a deeply conservative act needed to ensure that the benefits of the new rules would not be lost. The WTO was all about institutional structure and dispute settlement. These are the concerns of conservatives and not revolutionaries. That is why lawyers and legalists took the lead on these issues. The WTO codified the GATT institutional practice that had developed by custom over 3 decades, and it incorporated a new dispute settlement system that was necessary to keep the old and new rules from becoming a sham. Both the international structure and the dispute settlement system were necessary to preserve and enhance the integrity of the multilateral trade regime that had been built incrementally from the 1940s to the 1990s. First question. In the statement, it amounted to a recognition that international trade and its benefits cannot be enjoyed unless trading nations accept the discipline of a negotiated rule-based environment. It refers to what? Looking at the options, it is pretty clear that this is close to option A. The export gains many countries came to associate with a rule-based system. Remember the passage where it talks about people understood that the losses were less than the gains, and that was what led them to associate with the acceptance of this particular environment. Second question. What would be the closest reason why the WTO was not formed in the 1970s? Look at the initial part of the passage. In the first few sentences, it gives why this particular thing was not formed in particular time periods. Option B. Important players did not find it in their best interest to do so is the best option that can match the answer. Third one. In the method of interpretation of the European Court of Justice, actions against member states need to be evaluated against the set community goals. Near the end, they talk about teleological interpretation, right? The word teleological is used twice and it is explained what it means. So, best option A. Fourth, according to the passage, WTO promoted the technical legal values partly through integrating under one roof of the agreements signed under GATT. The first option itself is the one which matches the best from the passage. Fifth one. The most likely reason for the acceptance of the WTO package by nations was near the end of the passage. Go back and read, and the clear answer is given. Option D, it settles disputes more legally and more effectively, is eliminated. Its rule-based system leads to export gains, eliminated. Means to prevent US from taking unilateral measures, eliminated. The last one, they recognize the need for a rule-based environment to protect the benefits of increased trade, is the best possible answer to this particular question.